The message here really is, if at first you don't succeed, try again.
Praise for former President Donald Trump and other defendants in the Fulton County election interference case have taken the first step toward appealing Friday's disqualification ruling that allowed Fulton County District Attorney Fani Willis to remain on the case.
What I tell you, it ain't over.
Who have jointly filed this motion. They're trying once again to get Fulton County DA Fani Willis disqualified from prosecuting the former president and his allies. The motion arguing Willis's actions created an appearance of impropriety and odor of mendacity after a romantic relationship between she and a special prosecutor previously on the case came to light.
The courtroom drama is just as riveting as any Netflix movie. Today we're diving deep into the Fulton County case, Fani Willis versus Donald Trump et al. And co-defendants, where the state of Georgia is facing off against a presidential candidate right now. He has officially gotten the nomination from the Republican Party. Let's unpack the latest development here. A joint motion has been filed for a certificate of immediate review. Now, I know what you're thinking. Legal jargon, right? But trust me, folks, this document is the key to understanding the twists and turns of this high-stakes legal battle.
If it's granted, it would put the case on pause until an appellate court reaches a decision. But it is up to Fulton County Superior Court Judge Scott McAfee, who also wrote Friday's ruling, to grant or deny that certificate. Legal experts like defense attorney Bob Rubin, who is not actively connected to the case, have told 11 Alive that McAfee has wide discretion over whether to.
These defendants aren't just fighting for their innocence. They're fighting for their right to a fair trial. At the heart of this motion lies the fundamental question. Has the court's recent decision, Judge McAfee's decision to have Nathan Wade either step down or Fani Willis and her whole office step down, has this decision compromised the right to due process? According to the defense team, the answer is a resounding yes. If you were watching the news, it was wide-ranging on how divided people were in response to this unprecedented ruling in Georgia history. You remember the odor of mendacity that Judge McAfee said surrounds this case. That's why others see it as a blatant miscarriage of justice. It's a clash of the titans, y'all. You knew they weren't going to go out without a fight. But now they want an appeal. They're asking Judge McAfee for an appeal.
He may decide that he doesn't need to have an appellate court review his decision, that he's pretty certain that he's ruled correctly following the law as it's already been established. It's not a new area of law.
If the certificate is granted, Rubin says it would substantially delay the case, making it unlikely a trial would happen before the November election.
Let's break it down, shall we? Here are the key points from the defendants' joint motion. An appearance of impropriety. The defendants argue that District Attorney Fani Willis' actions have cast a shadow of doubt over this entire case, making it impossible for them to receive a fair trial. Specifically, the Georgia appellate courts, in applying their relevant precedent, including McLaughlin, would likely determine that disqualification of the district attorney is required when she has acquired a personal stake in the prosecution by laboring under an actual conflict of interest, including non-pecuniary actual conflicts, which defendants believe the evidence has established, or by creating the appearance of impropriety that this case has already determined she has created and remains here. They're saying immediate appellate review is also needed of the March 15th order declining to disqualify District Attorney Fani Willis based upon this personal stake that she acquired in this prosecution, both through her actual conflicts of interest and the appearance of impropriety created by her action. In its order, the court found that District Attorney Fani Willis's action had created an appearance of impropriety and an odor of mendacity that lingers on this case, as well as the continuing possibility that an outsider could reasonably think that District Attorney Willis is not exercising her independent professional judgment, totally free of any compromising influences. Despite this, the court declined to disqualify District Attorney Willis, finding that eliminating only Special Assistant District Attorney would cure the lingering appearance of impropriety. Well, the defendants believe that the relevant case law requires dismissal of the case, or at the very least, the disqualification of the district attorney and her entire office under the facts that exist here, and that the resignation of Mr. Wade is insufficient to cure the appearance of impropriety the court has determined exists. Forensic misconduct. They contend that the court failed to adequately address the issue of forensic misconduct, leaving the door open for potential bias in prosecution. The court also found that District Attorney Willis's nationally televised speech at Big Bethel AME Church on January 14, 2024 was legally improper. If you're saying it's legally improper, then I would think that that would show that there was some type of forensic misconduct, right? But declined to disqualify her on the basis of this forensic misconduct and the other forensic misconduct proven by the defendants, noting in particular a lack of guidance in Georgia case law for the standard for disqualification of a prosecuting attorney for forensic misconduct. So basically what he's saying here is we're in an uncharted territory, and there's never been a case that would guide him on what to do when a sitting DA is guilty of forensic misconduct. We're just making it up as we go. And the personal stake. The defendants claim that District Attorney Fani Willis has a personal stake in this case, citing conflicts of interest that should disqualify her from this case entirely. Immediate appellate review is also needed of the March 15th order, declining to disqualify District Attorney Willis based on the personal stake that she has acquired in this prosecution, both through her actual conflicts of interest and the appearance of impropriety created by her actions. So as another day closes in Fulton County, one thing is clear. This is not over by a long shot. So grab your popcorn, folks, because this legal showdown is just getting started. But anyway, do me a favor, like this video, comment, subscribe, hit the bell notification for all uploads. If you want to watch more, please watch one of these videos down below. It helps the channel in momentum and growing so we can get this message out to more and more people.